Hi, folks. Good Friday morning. My name is Greg McLawsen, and I am the Affidavit of Support lawyer. I've spent the past 10 years representing green card holders in federal litigation to enforce the Affidavit of Support. Today I am just got out of court on a motion where we obtained a judgment against the defendant in a civil case. And I wanted to make a video specifically for my existing clients because this comes up often about understanding the difference between winning a lawsuit, which is to say getting a judgment. We'll talk about what that means. The difference between winning a lawsuit and actually getting paid. So a lawsuit to enforce the Affidavit of Support, as is the case with most civil legal disputes, the point is to recover financial support, money, from the defendant. That is the one goal that the plaintiff is pursuing. So you would think, as the plaintiff, that if you successfully prosecute your case, or your lawyer does it for you, and you get a judgment from the defendant, that you've won, that's a good thing, and then you ride off into the sunset as a happy camper. That's not necessarily the way it goes. In the U.S. legal system, a judgment represents a finding by a judge that a party called the defendant owes a certain amount of money. So in the Affidavit of Support context, the Affidavit of Support sponsor has a legal obligation to ensure the plaintiff has income equal to 125% of the poverty guideline, roughly $17,000 per year. In a lawsuit where we are suing the defendant for a year's worth of financial support, we would expect the judgment in that case to be for roughly $17,000. So let's say we've brought our federal lawsuit, we've gone through the discovery process, we've filed a motion for summary judgment, and we win. And we obtain a judgment for $17,000 plus attorney fees and costs against the defendant. You might think as the plaintiff that the next thing that happens is the defendant simply writes a check because there's a court order, and you walk away the next day with $17,000. And that's not the way it works. In the U.S. legal system, there is a difference between that judgment, which is the judicial finding that you are owed a certain sum of money, and how that judgment is actually collected against the defendant. In most cases, happily, this is a good thing, a case is resolved voluntarily. This means either before a judgment is ever rendered, there's a settlement that's entered into, or once a judgment is entered into, the parties come up with an agreed arrangement as to how that debt is paid. That's in the vast majority of cases. However, if you have a case where the defendant at no stage of the process is willing to compromise, and you end up with a judgment against that defendant, and the only tools you have at your disposal are those available for involuntary collection. In that case, the money does not just show up automatically. And depending on the legal context and depending on the facts of the case, there are different tools available to you. So in the Affidavit of Support context, the federal statute authorizes basically the full gamut of potential collection tools that exist under federal law. This includes garnishing wages, garnishing bank accounts, and even seizing personal property and real property like houses. You can seize and foreclose a home that's owned by the defendant. Those are all very strong tools, but these aren't things that just simply happen automatically. And they're certainly not things that the court does for you. So if you end up in a situation where you've got your judgment and the defendant is continuing to be obstreperous and non-cooperative, your only recourse as the plaintiff and as plaintiff's counsel is to use those involuntary tools. So then you're in a situation where you're having to investigate what bank accounts does this person possess? Can we garnish those bank accounts? What are their wages like? Are the wages high enough that we can successfully garnish those wages and recover a reasonable sum of money? Do they own a home? If so, do they have an amount that is exempt from the homestead exception? Because there's only so much you can recover from a home if it's the person's primary residence. The reason it's important to underscore this is that going into the litigation process, a lot of my clients will tell me, I don't want to settle my case. I want to fight and win in court. Which I understand. What I think my clients are saying in that context is, I don't want to settle for less than I deserve. And you shouldn't. You should get the most value you can out of a case. However, the most productive path to getting the most value out of a case may not necessarily be to spend a year in court battling and getting a judgment from a defendant. Because if you go that route and you end up in a situation where the person gets the judgment entered against them and wants to sit on their hands and make you fight for every dollar you get against them, it might be a long time before you see all of those many pennies, all of the full amount of damages that the court's ordered against you. I have cases in the Affidavit of Support context where it was years that we were collecting garnishment against the defendant's wages, which you do ultimately get paid, but you're talking a long, long time. So it is often more in my client's interest and the plaintiff's interest to think early on about what an acceptable avenue is to getting a quicker form of relief from the defendant. So you might, as the plaintiff, end up wanting to compromise a little bit on the overall amount of money that you're seeking to recover, or you might want to compromise on the payment about how that settlement money gets doled out in exchange for certainty and in exchange for speed about how you accomplish getting paid, knowing that your alternative is not rock solid, in the sense that if you go through the case and you secure a judgment, you could still be at the beginning of another long legal process before you get paid. And by the way, if you, as the plaintiff, do end up in that lengthy process of getting a judgment and going through involuntary collection, the person that is the worst for is the defendant, because it is the defendant in that context that's going to be paying even more than they otherwise would have, and they will be getting money taken away from them in a way that is not to their particular wishes. It's just extracted from their bank account, or they lose their home. So sponsors who are listening to this, don't think for a second that you are winning by forcing a plaintiff into a situation where they take a judgment against you. The person who's going to lose the most in that situation is the sponsor. It's just that it's often everybody who's in a worse case. When parties can't resolve a case relatively early on and amicably, everybody loses and is in a worse case, is in a worse situation than they might otherwise be. It's just that it's the absolute worst for the defendant. So there you have it, the difference between a judgment and getting paid. I'm not saying that these cases in the Affidavit of Support context are not worth pursuing if the defendant isn't cooperative. We do that all the time. It's simply that we always do that in tandem with giving the person an opportunity to come to the negotiation table and to work out an agreement with us, because it's going to be better for everybody than going all the way to a judgment and going through the involuntary collection process. Hope that's helpful. If you have questions about collection in the Affidavit of Support context, feel free to drop it into the comments. If you would like an individualized case assessment, I work with folks all across the United States, and I'm happy to set up a Zoom consult with you. Just reach out to us on our website, soundimmigration.com. Hope that's helpful.